before Senior Magistrate Arita Forth this morning. The Department of Environment is attempting to levy new charges on Gabriel and Zabaneh. This is after DOE withdrew 6 charges against the 76-year-old mother and her 43-year-old son earlier this year. DOE had charged them for not adhering to stop orders in relation to a development being carried out on a seashore property in Caribbean shores. Today in court, legal counsel for the department, Javon Hulse, levied new charges for failure to obey an oral request as opposed to the previous charge of failure to obey a written enforcement notice. The defendant's attorney, Emil Arguelles, raised preliminary objections, arguing that the prosecution is attempting to have his clients charged for the same offenses which have been already withdrawn. Hulse explained the department's latest legal move against Gabriel and Zabaneh.
From what has happened, the first time we appeared before court, this is one of these situations where you always hear people go to court and things get struck out on technicalities. This is what they try to do, because clear as day, the offenses were committed. Everybody sees it. So now, what we are arguing and what had happened previously was that on the first occasion when we were before the court, when there were issues insofar as the documents that were tendered, submitted. Now, the department withdrew that. That was understood. We came back again. We had summoned them, but nothing happened on that occasion. And now, really and truly, this today, that is second time, really, they have been brought before the court. And so today now, there is this argument insofar as double jeopardy, that they were previously bought, a plea was taken, and that now we cannot bring the same charges again. And so today was essentially about hearing arguments on both sides as to whether they are right that the charges should not be brought again, or that the charges can be brought again. And we submitted that insofar as what has happened, the case lies in our favor. The court rules are in our favor that they can be brought again. And so that's what we did, and we argued, presented cases, and that's where we are.
According to attorney Emil Arguelles, this morning's proceedings did not require his clients to submit a plea. Arguelles' objections revolved around the prosecution's decision to bring forth new charges, which he described as abusive.
We had pleaded ultra for acquit, which is the legal equivalent of having been put in jeopardy and peril at a previous occasion. And it's a fundamental principle of law that a man should not be prosecuted twice for the same offense or on a series of charges. The prosecutor's argument in court was that he screwed up so much and so badly that it was as if nothing occurred the first few times, and therefore he should be given another bite at prosecution now. We argued that the prosecution ought to know what it's to do. He had stated that on the night before the last event, he had to be scurrying around to get a signature from Mr. Alegria, whose mom had died, and my condolences go out to him. But that's no way to run a prosecution, especially when my clients were served many days before. You can't be getting a signature on the night before, and when you don't get it, you come and use it as the excuse why you can't proceed. What's worse is that we were ready to proceed, and the magistrate was too. They sent us a letter saying we're withdrawing all charges. They could have adjourned the matter if they wanted to, but no, they withdrew the whole thing. Our argument was that commencement of a proceeding starts when a person pleads guilty or not guilty, which my clients clearly did, and that the withdrawal of the matter ended those proceedings at that point. To bring in again is abusive.
Then there is the matter of who owns the land in question. Parcel number 4670 was acquired by the government in 2016. But according to attorney Emil Arguelles, his client, Primrose Gabriel, is
these two. The worst part is, as I pointed out, was that this is a joke where you have the government saying that they have acquired this property, they own it, yet you have here the prosecution representing the government saying that the government does not own the land. Ms. Primrose owns the land, hence she's brought today to court for entirely new charges as an owner of the land. I have simply told the court that the prosecution, government's left hand should huddle with government's right hand and figure out what front and what argument they intend to take in this matter.
The alleged offenses were caught on camera, were captured over time. And you mean the DOE can't simply just bring a charge? You didn't say not the correct parcel number, Jevon.
They were typos, really and truly, I mean typos, insofar as the parcel number 4670. But again, the thing is, nobody know perfect jokes, and everybody know this.
Right.
That one learning curve, and these are some of the first cases where we really say DOE, they take the helm now and they start to prosecute environmental offenses. Now, not every day you hear what DOE matter go to court, especially magistrates court. So now you actually see DOE taking that step, making that learning curve. And so now that's what do they do?
You all are accusing Ms. Primrose Gabriel of violating the law on a parcel which is not her land. You all, the government, as you just underscored in court, acquired it in a gazette notice of November 2006.
All of the things come to light only recently. They don't really actually don't know what 3-4 weeks ago at best that the things arose insofar as the acquisition. Somebody charges me, maybe they found January.
Yes, but it's your ministry that acquired it, Jevon.
No, fundamental. You have Ministry of Lands, Natural Resources, separate and apart from forestry fisheries. So the lands matters are being dealt with by the Ministry of Lands.
The matter was adjourned to April 2nd. From the Magistrate Court to the Supreme Court, where inmate Hilaire Sears is suing the parole